Hi guys, let's talk about misconceptions about prenups in California. Misconception number one, either we don't need lawyers or we just need one lawyer. That's incorrect. Although in estate planning, one lawyer can draft estate planning for both parties, prenups include inherent conflict of interest, meaning one lawyer cannot represent both parties because their interests are against each other. When in estate planning, they're together planning future estate in case of death. In the prenup, they're planning future division of assets in case of a divorce. Not only assets, debt, and all their rights and obligations. So, number one, Code Section 1615 suggests that even if one party is not represented, the party who is affected by the prenup, so usually the party who gets less from the prenup, then that party should receive an independent memorandum of understanding about all the rights that party is waiving. In other words, it doesn't technically say that the party who is not represented the prenup means automatically not valid, but it creates such a hurdle for attorneys and parties and uncertainty whether this memorandum was well drafted, whether it included all rights and obligations. So the suggestion is that each party has their own attorney, and the reviewing attorney explains independently. First of all, the reviewing attorney has to be picked independently. So the drafting spouse cannot say, hey, get my friend Bobby, who is going to be reviewing it. His employment attorney, doesn't matter. Ideally, family law attorney, ideally family law specialist, speaking the language that the reviewing party speaks so that there is no issue regarding understanding the language of the prenup. Translation is also suggested. And independent, so that party picks their own. And I also suggest that the higher earner with the more asset party pays that party for their attorney, so that this truly independent choice of attorney with possibility to negotiate. So the suggestion is to have two attorneys, drafting and reviewing. One attorney cannot do it with that attorney. And in fact, there is a code section 1611 family code that states that if there is a spousal support waiver, then that portion is not valid if the party who is affected by that waiver, usually it's the receiving of spousal support party, it has been not represented. Number two, prenups can only be about divorce. That's also incorrect. Prenups can talk about estate, tax filing, pre-divorce, pre-marriage assets, post-marriage assets, reimbursement, spousal support, management of property. So all these things are part of the prenup. What prenup cannot talk about is custody, child visitation. And since California is a no-fault state, it cannot punish for things that would be against public policy, for example, being unfaithful. Number three, prenup can decide custody. So that was part of what prenup cannot decide. So prenup cannot decide custody, unfaithfulness, where the parties are going to live with the children. Or sometimes the prenup says, well, if you were unfaithful, then I can take the kids and move to Europe or something like that. So that would be not valid. Next misconception, we need to share every single document of everything we own. Typically, I have a clause that says if something is above $500, that's what we disclose in a list of assets and debt schedule. We do not always attach tax returns, business evaluations. The higher the stakes, the more likely the prenup is potentially going to be challenged. So it is suggested to attach tax returns, bank statements, credit cards, appraisals if there exist. But it's not a requirement. The requirement of 1615 Family Code section states full disclosure. Doesn't say how. It doesn't require to attach a form FL 142 and FL 150, which is asset and debt form, and FL 150 is income and expense declaration form. But I do it in my practice for the purpose of due diligence, so that the other spouse can say, yes, I reviewed everything, I have no questions, and therefore I'm signing this prenup fully informed, and also waive final disclosure, meaning I don't need to know anymore. And another thing that I notice, people think to believe that they only need to disclose assets located in the United States. That's incorrect. All assets, all real estate outside of the United States would need to be included in the assets and debt attachment to the prenup. Final misconception is we can just sign the prenup right before the wedding, meaning when it's presented and right away sign. So you could print it out online, or one lawyer prepared it. You waive the lawyer reviewing it, and we just sign it. There is a 7-day rule, again, code section 1615 Family Code, that states the final version of the prenup should be untouched with any significant changes between the date it has been negotiated and finalized and signing. The parties can sign it right before the wedding, as long as full calendar 7 days have been in between final version and signing. I hope that was helpful, and I will see you in my next video. Bye!